So, good evening, learned audience. I am Diptar Kurai, a patent and trademark agent working in biotech domain, representing LS Davar and Company, the most trusted as well as one of the older IP law firms working since 1932. We have our head office in Kolkata and branches offices in Delhi and Bangalore. We thank WIPF for offering such a wonderful platform for IP practitioners. Coming to my topic, it's sufficiency of disclosure addressing the requirement. Regarding sufficiency, the invention must be fully and particularly described. The invention must be enabled. The enablement may be considered as a quantitative disclosure, how to carry out the invention, detailed description of product and or process, use of invention through examples. Whatever you write in the complete specification, preferable disclosure should be in the form of generic to specific. That means from a broader scope, and you gradually narrow down the scope. Satisfaction of objectives mentioned in the complete specification. Now, the best mode contemplated to carry out the invention is often qualitative. Best phrase is actually superlative, so definitely there should be other modes, amongst which one mode should to be considered as best mode. The preferred embodiments are to be disclosed, may also have only one mode. In that case, if that is claimed categorically, it should be considered sole and best. May refer to either inventors or applicants. And bottom line is, the sufficiency may be considered as the combination of enablement and best mode requirement, wherein the enablement requirement is a mandate across the jurisdiction, best mode is not, and these two requirements are not same. Often it is perceived as same and very similar, but they are not the same. So the prima facie requirement of patenting a novelty, inventive step, and industrial application, sometimes called as utility, usefulness in some other jurisdiction. In India, it is disclosed under Section 2. Another prima facie requirement, standard essential criteria of patenting is disclosure requirement. The disclosure requirement is delivered under Section 10 of the Indian Patent Act. So the enablement across jurisdiction and the base mode in some jurisdiction, as I told earlier. So unlike publication of original peer-reviewed paper, review or article, these publications are offered free of cost anywhere. Any patent application will be published automatically on the expiry of 18 months from the date of filing. But the original paper, the public need either to subscribe or need to purchase an article. Some papers offer themselves free, but most of them needs a subscription. So it's a free knowledge offered to the world, offered to the society in exchange of a 20 years, a limited time of monopoly. So it obliterates any possibility of dual protection as well. In some jurisdiction, trade secret protections are available. It may happen that an applicant is filing a patent application and the broad protection may be covered by a patent, but the best mode is hidden and that is covering a trade secrets. In that case, actually, the objective of patent domain is not fulfilled. So the base mode requirement is very much into place. Let's see what TRIPS agreement talks about this sufficiency. Article 29 of the TRIPS agreement says, members shall require that an applicant for a patent shall disclose the invention in a manner sufficiently clear and complete for the invention to be carried out by a person skilled in the art, and may require the applicant to indicate the best mode for carrying out the invention known to the inventor at the time of filing, or that means at filing date, or where priority is claimed at the priority date of the application. That means it clearly says that Article 29, it talks about a patent applicant for a patent shall disclose the invention in a manner sufficiently clear and complete for the invention to be carried out by a person skilled in the art, whereas it may require the applicant to indicate the base mode. That means from the wordings, it is clear, pretty much clear, that the enablement disclosure requirement, it is compulsory to all member states, WTO member states. The best mode disclosure requirement is actually optional for member states. It is their discretion whether they want to mandate it or not. It refers inventor's knowledge. Is the only one article which is referring to inventor's knowledge rather than applicant's knowledge. The reason why it does that, because it has been taken from the US Patent Act. So they put that they refer inventor, US refer inventor, so TRIPS also refer the inventor. So the update in technology may change inventors' perception and information on best mode. So actually, the best mode verification is a little bit cumbersome, because you have to go back to that time when the patent application was filed, or actually when the patent was designed, when the patent was in an experimental stage or verification stage. That time, with that particular available set of knowledge, and that time what knowledge, what information inventor used to possess, that is very important. Of course, you have to cut short something called hindsight bias, and it is always, this kind of, verification is based on, it's a subjective verification. Actually, it is based on circumstantial evidence, and it often take time. So I'll come to this particular topic later on. The sufficiency, let's say what US talks about sufficiency. So the first para, section 112, title 35 of US Patent Act 1952, that is USC, United States Code, it says it actually requires the inventor to adequately describe the three elements in the patent application. It is very much similar to section 10 of our act. So one, a written description of the invention itself. Two, the manner and process of making and using the invention. It is nothing but enablement. Three, the best mode contemplated for carrying out the invention. So the TRIPS adopted the best mode requirement for USA. Enablement is mandated, and it refers to inventors. So the entire thing actually is taken from US. A valid reason for refusal of the grant of patent, valid ground for opposition, and invalidation suit. That is in US. However, it is controversial because of, you need to establish there should be a subjective analysis as well as objective analysis to to understand whether the best mode has been disclosed properly or not, and a lot of litigation, invalidation suits. So finally, US came up with a Patent Reform Act 2007 cleared by the House of Representatives. It says the best mode requirement continued to apply to all patents, but it is no longer form the basis for a defense to a charge of patent infringement during enforcement litigation or post-grant review proceedings. So the compliance with the best mode requirement would remain subjected to the review by USPTO examiners during the initial part of the prosecution of a patent. It is still valid for refusal, cancellation, and invalidation by the examiners only. Examiners can raise objections, the controllers can raise objection, but it cannot be, any other person, interested person cannot file an invalidation suit or cannot do a post-grant opposition, because there is lacking of the best mode requirement. It is not satisfied. We cannot really allege and file an invalidation suit. Sufficiency in Japan. Now, Japan, historically, Japan took this enablement, their patent act from Germany and US. So like US, a patent applicant needs to disclose the invention with how to make and use the invention, along with the best mode contemplated for carrying out the invention. So both US and Japan requires the patent to disclose the specific technical information beyond enablement. However, Japan refers to the applicant, whereas USA refers to inventors, so is TRIPS. So basically, what Japan did, in the guideline of examination of patent and utility models, in the section 3.2.1 in part 1, they say, patent applicant to describe in the detail at least one mode that the applicant considers to be the best among the various modes of carrying out the invention, complying with Article 36.4.1 of Japanese patent law. So basically, this is not in the act, but in the guidelines. So there is no reason for refusal of grant of patent application. Of course, there will be reason for objection, but there will not be a refusal for grant of patent application. It's softer requirement than USA because this is kind of the Japan kind of took a middle path of Germany, which Germany doesn't have a best mode requirement. They categorically announce it, and Japan has a best mode requirement, but they don't enforce it so strictly as US does. Then in China, the best mode requirement is phrased as preferred mode. Rule 18 of implementing regulations, it provides the description of embodiments of the invention. The patent application shall describe in detail the preferred mode contemplated by the applicant for carrying out the invention. It refers the applicant. Again, it's not a provision under the patent law and not a reason for refusal as well. It's an ineffective rule in a way. The State Intellectual Property Office, aka SIPO, Chinese courts, they never enforce the preferred mode requirement in invalidation or appeal cases. It is very soft, I mean, way softer requirement compared to USA. In other jurisdictions, let's say European Patent Convention, Article 83, EPC states the European patent application must disclose the invention in a manner sufficiently clear and complete for it to be carried out by a person skilled in the art. So basically, it's an enablement requirement which is disclosed. Germany, it is most notable, they explicitly renounce the best mode disclosure requirement, which I was talking earlier. They say in the examination guideline that it is not relevant to the issue of disclosure of the invention whether an item in the description has been mentioned as advantageous, useful, or preferable as compared to other simultaneously disclosed solutions. Best mode also exists in Canada, Ghana, Mexico, New Zealand, Zambia, South Africa, and many other countries. In Australia, Ireland, Mexico, for example, they're termed as best method disclosure. Like in China, they called it preferred mode. Section 42A of Australian Patent Act says a complete specification must describe the invention fully, including the best mode known to the applicant. Best method known to the applicant, not best mode known to the applicant. Fully including the best method known to the applicant. So there is a little difference in the phrases. So this is how sufficiency is actually interpreted in India under Section 10, specifically under Section 10(4) of the Indian Patent Act 1970. I will talk about this later. This Section 10 talks about, I am coming to the next slide, wherein everything is categorically disclosed. So India has made enablement as a valid ground for opposition as well. So let me first brush up the Section 10(4). Section 10(4)(a), it says fully and particularly describe the invention and its operation or use and the method by which it is to be performed. So Section 10(4) says every complete specification should have the details. So this is enablement. If you don't have that, your patent application is subjected to opposition. It may be subjected to opposition under Section 25(1)(g) in the pre-grant state, and in the post-grant state, if it is granted, under Section 25(2)(g). All right. Now, in the B, clause B, it should disclose a complete specification should disclose the best method of performing the invention which is known to the applicant and for which he is entitled to claim protection. So this is the best mode requirement. Categorically speaking, it is not there in the post-grant or pre-grant opposition section. However, it is very much present in revocation of patents under Section 64(1)(g). A patent may be revoked. A patent may be revoked if it does not sufficiently and fairly describe the invention and the method by which it is to be performed. Also, it may be revoked that if it does not disclose the best method of performing. If it does not disclose the best method of performing which is known to the applicant for the patent and for which he was entitled for claim protection. So basically, therefore, these two are very important. Both enablement and best mode. All right. So basically, Section 25(1)(j) allows pre-grant opposition if it is questionable. Section 25(2)(g) allows post-grant opposition if the requirement of best mode is questionable, and it may be revoked under Section 64(1)(g) if those details are not there in your complete specification. So the sufficiency for patent application with biological material. What is the scenario in India? You just again look at Section 10(4). It is disclosed in these three parts. A common objection. It's a common objection that sufficiency, the controllers always seek source and geographical origin. That's a mandate under Section 10(4)(d)(2)(b). The source and geographical origin must be disclosed. So that's also a prima facie requirement. If you are using a biological material, you must disclose the source and geographical origin. And if the biological material is from India, is taken from India, procured from India, produced in somewhere, some from traditional, some groups, some tribal, some something. Definitely, you must take an NBA approval prior this patenting. So NBN approval from National Biodiversity Authority is very much important. If the source and geographical origin is India, even if the source and geographical origin is not India, we must disclose the source and geographical origin of biological material. So basically, it again says in D2, section 10.4 D2, if the applicant mentions a biological material in the specification which may not be described in such a way so as to satisfy clauses A and B. What are A and B? A is enablement and B is the best mode requirement. And if such material is not available to the public, that means if such materials are not deposited, that means if there is a deposition, there will be an accession number and all the characterization will be there tagged along with the accession number. Okay. But if such details is not there available to the public, the application shall be completed by depositing the material. Of course, under the Budapest Treaty, there are certain International Depository Authority, IDA abbreviation is designated. In India, there are two IDAs. One is NCCS Pune and another one is IMTech Chandigarh. Okay, so you have to deposit it and then file a patent application. In some cases you may file a patent application and complete the deposition and all the formalities within 3 months of filing the patent applications. But otherwise, it is always preferred that you deposit first and then file the patent application. Now, there may be a scenario. Let's say the biological material has been deposited. It has been deposited. It was deposited, let's say, a decade ago. Now you want to do certain research with that biological material. So you procure that biological material, you did something, you file a patent application. Now in that case, the deposition is there. Now let's say that depository authority is not an international depository authority under Budapest Treaty. What should be the consequence? Actually, there might be some objection that why didn't you deposit it in an international depository authority? However, depositing anywhere well before filing the patent application, it should address the enablement requirement, because all the details along with the accession number and every characterization is actually there and it is available for anybody to procure, to collect. Okay, so deposition in IDA, maybe it should be a mandate for application filed under PCTR convention. And also, if you are using certain biological material from India, NBA approval is a must prior going to the international stage. So basically, what is the summing up is, if you have already deposited and you are working with the already deposited material, that should suffice the requirement. Even if you did not deposit in an international depository authority and you are filing a patent application in India. So the effect on grant of patent, we are summing this up. India has made enablement as well as best mode requirement as a valid ground for revocation under section 64. We have already talked about it. So the best mode provision is not directed to a scenario where no mode has been disclosed. So no mode has been disclosed means there is no comparison exist. But if there is no mode disclosed, that is amounting to non-enablement. If it is not enabled, the specification, the patent application is liable to be rejected. So where only one mode has been disclosed clearly and categorically, with example, duly claimed best mode requirement should be considered as at rest in absence of any possible comparison between other modes. So in US, however, best mode requirement is important for grant as well as ground for opposition and invalidation, like in India. Subjective analysis, there are two types of analysis. I already talked about it earlier. There is subjective analysis as well as objective analysis. So the subjective analysis is focusing on the inventor's then state of mind. Trying our best to cut short the hindsight bias. That means That means in 2021, if we wanna analyze certain, state of mind existing information back in 2009, in 2021, if we are trying to decode it, we have to check the lab notebook, we have to check the papers publication, the discussion, if there is any recording available in some public forum of the inventor, that what was in inventor's mind. So it's always circumstantial evidence, it's very much time consuming, it is expensive, of course. And and there is always a hindsight bias which has to be cut short. Now coming to the objective analysis, now that is whatever is in the written description, the whether the base mode is there, whether it has been enabled, whether it is practicable for a Foshita. In United States, Foshita is person having ordinary skill in the art, Foshita. So as of now, as per Patent Reform Act 2007, the base mode is a substantive condition for patent grant, but not for invalidation. I'm coming to this. The US has amended in 2007. Okay, so you cannot really challenge, you cannot really do an opposition, you cannot really file a post-grant opposition, or you cannot really file an invalidation suit. However, the examiners can certainly object based on that and can certainly reject a patent application if there is no base mode available categorically in the specification. So Germany has no base mode, Japan and China it is softer. However, enablement is must everywhere. So I'll just brush up with some case law in India. Ajanta Pharma versus Allergan, IPAB held that data and particularly comparative data was essential at the time of filing of the application to support any advantage and claims of an invention. Loreno Healthcare Kibo Biotech versus Kibo Biotech, when it was stated that there must be express support for a claim process and that there must be examples which support the alleged invention and which can justify such claims to any advantage. And in India, Ram Narayan Kher versus Ambassador Industries, it's an old case, 1976. Delhi High Court identified that claim revocation is possible under section 64(1). There's an order, IPAB revoked the grant of a patent on the grounds of lack of novelty as well as insufficiency. Patent is request for amending the claims was not allowed due to not having support in the description. So this actually goes with section 57 to 59 of the Patent Act as well, which talks about amendment. So coming to a scenario which I talked earlier about is, if you have disclosed only one mode, claimed that mode only, and there is no best mode, you didn't categorically represent any best mode. You didn't say that there are 4 modes and there is, the mode number 2 is the best. Rather, what you have done is there is only one example and you have claimed only that. So in that case, what may happen? There's a case actually, there's a patent number 184038. It's a patent is from, I think, Hindustan Lever. IPAB concluded that the sufficiency requirement is addressed even if at least one way of working the invention is clearly described, enabling a person skilled in the art, a skilled person, excuse me, to carry out the invention. Exemplifying all conceivable ways of operating the invention may not be required if the best method known to the applicant is disclosed in the specification. So it will satisfy the sufficiency of disclosure requirement under section 10. So SCAs should may disclose only one example wherein the parameter falls within the range, whereas claiming said range, the enablement requirement should be addressed, should be considered as addressed, and so is the best mode requirement. Okay, and conclusion. For sufficiency, the invention must be enabled, but best mode requirement is territorial, often optional, by TRIPS agreement as well. So the TRIPS actually gives free hand to the member states that they can make it optional, they can make it mandatory. Like India, it is mandatory. In US, it is mandatory. In many jurisdictions, it is not. So the best mode disclosure offers an ideal trade-off against a monopoly or for a limited time, adds to the quality. Now, coming to the third point, a broad claim claiming a range without specific example may not stop the grant of a narrow claim claiming specifically while disclosing with example. The non-disclosure of base mode thus may jeopardize the validity of patent. I'm just explaining a little bit. Let's say there's a chemistry application in chemistry domain. Most of the time, the chemistry application, the API application, the product application, they use Marcus mode of claim. The Marcus mode of claim can claim a million compound, maybe even more. In combination, if you properly apply the permutation and combination randomly, it may end up claiming a million compound. Now, if there is no example categorically disclosing what you have actually done and for what you are, seeking the protection, uh, another patent application later on may just disclose the best mode, claim that particular part, and can get a patent on that narrowed down scope of the invention what you have designed. So basically, it may jeopardize the validity of patent even if you know the base mode and you are not disclosing it. And if someone else discloses it, get a patent, then you will be excluded from practicing that particular part. So the rivals, competitors, importers, they may produce the product or build around the existing product, creating a niche if the best mode disclosure is there. So the requirement to inventor in United States code in TRIPS to applicants in India, Japan, is the ground for refusal in US and India. So that is the summation. So the more information, since the more information is available to the inventor, inventions are generally considered the products, the baby of inventors. So the information should reside with the inventors only. Generally, what happens, the applicants are often the employer and the inventors are employee, most of the cases. So generally what happens, automatically the inventors assign their invention to the applicants. So referring inventor is always preferred than that of referring the applicants. Sometimes it is termed as best mode disclosure, preferred mode in some jurisdiction. It should be made a substantial condition for patent eligibility, that is objectable if not found in the specification by the examiners of the controllers of the patent office. However, it should not constitute a reason for invalidation or opposition. So, in sum, we are saying the best mode requirement should be there in patent application. Otherwise, the quality of patent, it may deteriorate and it will not be open to the public. So that is how it should be there with certain kind of limitation. So any questions? I welcome any questions for the audience. Thank you. Thanks very much.